Hello, my name is Christopher Robertson. I'm a professor here at Boston University School of Law and one of the leaders of our health law program. And it's just delightful to see 38 people joining us today for this second day of our conference on legalization of marijuana. This panel in particular is on legalization of marijuana on a national level. And we have three speakers running between 9:30 and 11 o'clock. Our three esteemed speakers, I'll go ahead and announce the first one, and we can lead right into his talk. But let me start backwards. Our third speaker today is Rosario Cuerlo, and our second one is Robert Mikos. And our first speaker we'll be hearing from is Alex Kreit, assistant professor at Northern Kentucky University, Chase College of Law. He'll be talking about federal cannabis reform and the Controlled Substances Act. While he gets his slides started, I'll mention that we have a chat box in the bottom where we can be taking your questions as they come, and your comments and your counter arguments. And then we'll have time at least half an hour or so at the end for you to then engage in that discussion through the chat box, and we'll be asking the panelists to discuss amongst themselves and follow up. So there we have it. Alex Kreit.
Great, thank you so much. It's great to be here this morning, or well, I mean, I'm just in my basement, but it's great to be virtually here with everybody this morning. And I want to thank Jay Wexler and the Law Review for organizing this really fantastic virtual gathering. My focus in this presentation is going to be on sort of the relationship between the Controlled Substances Act and efforts to reform federal marijuana laws. And, you know, this is, I think, a subject that has been largely overlooked in the conversation about federal marijuana reform for very good reason. The discussion about federal marijuana reform, I think, has mostly focused on questions like how will federal marijuana reform affect public health, how will it affect the market for marijuana, how will it affect things like taxes, what will the impact be on existing state marijuana laws, you know, should there be direct federal regulation, should there be direct federal taxation, how will federal marijuana reform affect, you know, criminalization and the lingering effects of criminalization and the racial inequalities and enforcement of marijuana law and all those kinds of things. And I think lost a little bit in the conversation is the relationship between federal marijuana reform and the Controlled Substances Act. Also perhaps for good reason, because people, I think, have generally rightly assumed that, you know, in order to achieve federal marijuana reform, we just kind of have to take marijuana out of the Controlled Substances Act in some form or fashion. But, you know, I think, you know, I'm going to, in this presentation, suggest that for the occasion of marijuana reform, which I do think at this point, you know, really is a matter of kind of how and when and not if, is an opportunity and should be looked at as an opportunity to rethink the Controlled Substances Act a little bit more fundamentally. Because I think the experience of marijuana under the Controlled Substances Act, both in how it's been regulated over time and what we see as far as how reform proposals treat marijuana and the Controlled Substances Act, suggests a need to really rethink the Controlled Substances Act more fundamentally, to have more consistency, to have a more rational regulatory system for controlled substances, more broadly speaking. And so to set the stage, I'm going to kind of start with an overview of the Controlled Substances Act and marijuana's status under the Controlled Substances Act. And I'll mostly be using the term marijuana, since that is the term still used under you know, federal law, and I'm talking about the you know, current federal status. So the CSA was enacted 50 years ago in 1970, and before the CSA, drug prohibition was kind of carried out under a few different statutes. Not all of them were administered by the same agency. And one of the driving forces behind the CSA, the Controlled Substances Act, and its passage was to kind of take all of the then existing law regulating illegal drugs or criminalizing illegal drugs and put it under a single umbrella, put it under, a single agency, which, at that time was Bureau of Narcotics and Dangerous Drugs, and eventually ended up becoming the Drug Enforcement Administration in 1973. And perhaps most importantly, kind of develop a regulatory and criminalization system that would allow for the DEA eventually to criminalize new substances on an ongoing basis without the need to go to Congress and without the need to pass new legislation piecemeal over time, which had been more or less the approach before the Controlled Substances Act. And the CSA kind of achieved this goal of one regulatory structure and a regulatory structure allowing for continuing criminalization administratively over time through a scheduling system, which I imagine most or of all of us are generally familiar with at the very least. So I won't, go too much into detail in it, but of course, just kind of for some of the basics and some of the points I think that are especially worth keeping in mind in the discussion about marijuana reform and the CSA. We, have this kind of 5-schedule system for the Controlled Substances Act, right? And in the 5-schedule CSA system, you have the really 3 criteria, right? That are kind of 3 regulatory criteria: the potential for abuse, the accepted medical use, and kind of the safety dependence profile of the substance. And, marijuana, of course, is a Schedule I substance. And there are many, many notable things about the CSA, and I think many quirks and oddities about how the CSA operates. But I want to focus on just kind of 2 points that I think are especially important to keep in mind and think about when we're talking about sort of both why marijuana is still in Schedule I and what the relationship between marijuana reform and the CSA, sort of is in terms of the efforts and what that might mean for the CSA going forward. So, I think first of all, it's important to kind of appreciate just how much power the DEA kind of wields over the definition of these scheduling criteria, which I think is both a big part of the story of sort of marijuana's continuing Schedule I status and why it might be that there should be kind of a broader rethinking of the CSA. The Congress did not define any of these terms, any of the scheduling terms, and they're very, very open-ended, right? Congress did not define what it means to have a potential for abuse. Congress did not define what it means to have a currently accepted medical use, and it did not define anything about the safety independence profile. In fact, the only term that Congress defined in the CSA was the term, as far as the scheduling criteria, was the term United States, which is actually part of the term for medical use. The accepted medical use standard is currently accepted medical use in the United States, and Congress did define United States in the CSA as far as the scheduling criteria. But other than that, Congress kind of left it open-ended. And for anybody who knows, even just a little bit about administrative law, you probably catch the implication of that, which is that the DEA, as the agency that is now administering the Controlled Substances Act, has been delegated that authority by the Attorney General, who is the entity mentioned in the CSA itself. They have basically, I wouldn't say unlimited discretion, certainly, because they have had some of their, interpretations overturned, but they have a great deal of discretion in how to define these terms. And, as we'll see, and I'll talk about more in a moment, they have, come up with terms that certainly leave marijuana, I think, very firmly in Schedule I as long as those definitions are in place. The other thing that's important to keep in mind when it comes to the relationship between the Controlled Substances Act and federal marijuana reform, that I think most people probably, or many people, anyone familiar with the CSA understands at least at some level, but is often underappreciated and sometimes is a surprise to people when they kind of, hear about or generally familiar with the idea of this scheduling system, is that, regardless of the schedule of substances in, it is still illegal to distribute that substance for non-medical or, quote unquote, recreational purposes, for purposes that are not deemed as acceptable under the CSA. That includes Schedule 5 substances, right? It is, whether a substance is in Schedule 1, 2, 3, 4, or 5, none of these substances are going to be legal to distribute for, a non-medical, a recreational purpose, and non-medical meaning sort of within the definition of the CSA itself. And that is, of course, important because even if marijuana were to be rescheduled to the lowest schedule, to Schedule 5, that really does nothing to resolve in any way, shape, or form the conflict between state and federal marijuana laws, the fundamental conflict of this being a substance that's illegal under federal law, right? It is, even Schedule 5 substances, are not legal to be distributed for, non-medical uses. And, it's fair to say the penalties for Schedule 5 violations are relatively low. The kind of differences between Schedules 2, 3, 4, and 5, the main differences are going to be as the schedule gets progressively lower, there's less regulation and oversight. And generally speaking, the penalties are going to be lower, although there's some kind of exceptions as far as mandatory minimums or the sentencing guidelines for specific substances. But the penalties certainly still exist. For a general Schedule 5 substance, it's going to be up to a year, and they still carry a lot of the same sort of collateral consequences as any other Controlled Substances Act violation. The 10th Circuit just last year upheld a deportation for somebody for a conviction, a state law conviction for possession of a Schedule 5 substance, codeine, on the ground that it was Schedule 5 under the federal CSA. So, again, with respect to marijuana, this of course means that even if you were to move marijuana from Schedule 1 to Schedule 5, that's not going to solve the conflict. And this brings us to the kind of current status of marijuana under the CSA, which is, of course, as a Schedule 1 substance. And, I won't go obviously through sort of the long history of efforts to reschedule, but I think it's helpful to kind of just briefly appreciate why this is a Schedule 1 substance. Now, most of the litigation, I think most of the attention sort of in the policy discussion about marijuana's Schedule 1 status focuses on the accepted medical use criterion in the Controlled Substances Act. And the accepted medical use criterion is certainly one of the reasons that marijuana is in Schedule 1. And it's one of the reasons I think marijuana, as long as this definition, which is on the screen here, the definition that the DEA has adopted, and in particularly the first factor in the DEA's definition, as long as this is part of the definition of medical use by the DEA, I don't think marijuana as a plant is ever going to be found to have an accepted medical use and treatment in the United States by the DEA. Because the DEA has said that the chemistry of a drug has to be known and reproducible for there to be an accepted medical use. And of course, as the DEA has said repeatedly in the context of rescheduling petition denials, marijuana as a plant, the marijuana plant, broadly speaking, doesn't have a known and reproducible chemistry because there's different strains of the marijuana plant, for starters. And, that's just going to be kind of always a true fact about marijuana. And unless until the DEA changes its definition of currently accepted medical use and treatment in the United States, that is, a barrier too. And I think probably one of the main reasons why marijuana remains in Schedule 1. But just as important, I think oftentimes overlooked, is the, sorry, just opening up my timer, is the fact that the DEA has also found that marijuana has a high level potential for abuse, right? That it should be placed in Schedule 1 for that reason as well. Or if it were to be rescheduled, in the unlikely event that the DEA were to change its definition of medical use and it were to be rescheduled, then it would have to be in Schedule 2 because it has a high potential for abuse. And why is that, right? Why would marijuana be considered a drug to have a high abuse potential? Well, again, it kind of goes back to the DEA's definition of the term. The DEA, in assessing sort of abuse potential, places a lot of weight on how many people are using the drug outside of medical supervision. Just literally the sheer number of people in the United States who are using the substance. And that is kind of consistent with that approach. One of the main things, perhaps I think it's fair to say the primary thing that the DEA has cited repeatedly in its rescheduling petition denials as to why it is that marijuana has a high potential for abuse. It literally is just the sheer number of people who are using marijuana. The DEA says there's lots of people doing it. It's widespread, and so therefore there is a significant potential for abuse. And again, as long as that definition is, as long as that's part of the DEA's definition of potential for abuse, marijuana is going to be considered by the DEA to have a high potential for abuse. And so, what is this kind of, where does this sort of leave us with marijuana reform in the CSA? I think a good starting point for appreciating the relationship between marijuana reform and the CSA is to kind of think about the question of why aren't alcohol and tobacco Schedule I substances? A question that, of course, I'll sort of ask rhetorically here in the virtual setting. And the reason is that they are statutorily exempt, right? I mean, if you think about alcohol and tobacco, they would absolutely meet the criteria of Schedule I, but they are exempt by statute. But the CSA, when it was passed, specifically exempted them. Not surprisingly, I would imagine the lobbyists for those industries would not have been happy if there was not a statutory exemption. And consistent with that kind of approach, most reform proposals for marijuana, so to date, kind of take a similar approach for marijuana. They basically just, the way that they deal with the conflict between state and federal, or between the federal, between marijuana and the CSA, is to just say, we're going to remove marijuana from the CSA. The, MORE Act, which is the, I think, kind of leading candidate at this point for moving through Congress, one that is apparently going to get a vote in the House, although they said that before the election too. So we'll see what Democratic leadership actually does, but seems likely to get a vote in the House before the end of the year, although, a symbolic vote at this point. But it basically just says we're going to take marijuana out of the CSA, and it directs the DEA to do a rescheduling rulemaking to take marijuana out of the CSA. And so, for other prominent proposals, Cory Booker's proposal does this sort of same thing. Some proposals keep marijuana in the CSA, but just would allow for exceptions to criminal punishment for people whose conduct is in compliance with state law. But kind of the broad proposals, the proposals to just kind of legalize marijuana federally, if you will, kind of take it out of the CSA. And what I'll end with here is just sort of a few thoughts about why perhaps this experience in this kind of regulatory structure in the treatment of marijuana under the CSA maybe suggests that it's time to rethink the CSA rather than just to sort of add another carve out for marijuana. Because if the CSA is truly meant to and intended to be a sort of regulatory structure for all substances, of quote unquote abuse, all substances, mind altering substances that people use outside of strictly medical confines, I think we have to kind of acknowledge the fact that the experience of regulating marijuana, treating marijuana under the Controlled Substances Act has, indicated that there are some, holes or flaws, or at least areas of, that are open to criticism and debate. And I think, certainly as a matter of efficiency in politics, it makes good sense to have marijuana reform proceed as it is, right? I mean, it's going to be a lot easier to just take marijuana out of the CSA than it would be to fundamentally rethink the CSA. But I think at the very least, as part of this conversation, this is something policymakers in Congress should start looking at. This could be something, more narrow, right? A more narrow conversation sort of focused on the current CSA scheduling criteria, right? Questions like whether Congress should adopt new definitions, or maybe the DEA should reconsider its definitions. The DEA certainly has that authority as a regulatory agency to look and say, maybe we should rethink how we define currently accepted medical use, how we define potential for abuse, and perhaps do so in a way that would be maybe more consistent with marijuana ultimately being excised from the Controlled Substances Act. Maybe Congress could even consider altering the criteria in some way, but keeping the overall framework. Of course, a more fundamental or a broader kind of rethinking or reimagining of the CSA might go even further, right? Maybe the CSA should add a new category for substances that have no medical use, but a very low abuse potential, which currently, in fact, the CSA doesn't really have a category for that. Or perhaps the CSA should even consider, or Congress should even consider amending the CSA to provide a regulatory path for legal intoxicants within the CSA itself, to acknowledge in some way formally in the CSA, beyond just an exception, the legal status of marijuana, of alcohol and tobacco, and I think before too long, marijuana. And so with that, I think I'm at my time, so I'll leave it there. Thank you.
Well, thank you so much, Professor Creit. That was a very helpful presentation, and it's great seeing the advanced Zoom video skills here. Many of us are trying to stay ahead of that curve. So we have 2 more speakers today, and I'm seeing comments coming in the Q&A, which we'll be excited to address by text or orally. Our second speaker is Robert Michos, professor of law at Vanderbilt University, and he'll be talking to us about the question: are we headed toward a national cannabis market? Take it away, Professor Michos.
Thanks, Christopher. Thanks, Christopher, and thanks to Jay Wexler and all the folks at BU for putting together this wonderful symposium. Really appreciate being a part of this. I am going to be talking about the development of this national cannabis market as I foresee it. What's interesting is that we have more than 30 states now that have legalized cannabis for at least some uses. And these states have licensed literally thousands and thousands of firms to supply the drug to consumers. Last year alone, for example, in 2019, those firms sold a combined $13 billion worth of cannabis throughout the nation. What's remarkable, however, is that none of that cannabis that's now being produced and sold, none of it is being sold across state lines, not legally anyway. So licensed shops in each of these states only sell cannabis that was produced by firms that are also located in the same state. So for example, last year, 2019, licensed shops in Colorado, both medical and retail, sold a combined $1.75 billion worth of cannabis. But all of that was sourced in, all of that was cultivated and processed within the state of California. So we don't have a national market for cannabis right now. Rather, what we have are 30 plus state cannabis markets. And not surprisingly, these state markets for cannabis, they stand in stark contrast with the national markets that we have for almost all other consumer goods. Including beer, pharmaceuticals, cigarettes, produce, fast food, you name it. Most of the goods that we see on store shelves right now are not produced in our own state. They're oftentimes shipped across state borders, oftentimes imported from other countries. So today I'm going to be talking about or quickly addressing three questions surrounding these peculiar state markets. But I want to drive home one point at the outset, really emphasize one point at the outset, and that's that these state markets, I think, aren't going to last for long. The state markets are going to decline and quickly be replaced by a national market for cannabis, even if Congress doesn't adopt any new legislative reforms like the Moore Act that Alex just mentioned. So let me get into those three questions real quickly. They're all sort of interrelated. And the first one is, why do we have these state-based markets? Why aren't firms selling across state lines right now? And it's not the reason that you might think. It's not the reason that most people give, which most people blame this on the federal ban on cannabis. Now, it's true that the federal government under the CSA bans all sales of cannabis. That's something we all know. It's been drilled into us. But the important thing here is that federal law doesn't distinguish between sales of cannabis that take place entirely within one state and sales that take place across state line. So the sale of cannabis between two people in Denver, Colorado, that takes place entirely within the confines of Denver, Colorado, is just as illegal as the sale that goes on between, let's say, a Colorado vendor that ships its wares out to Oakland or to San Francisco. Both of those sales are equally unlawful. So that raises the question, why has the illegality of cannabis sales, why has it stopped only those interstate sales, but it hasn't stopped those $13 billion worth of intrastate sales that are going on right now? We can't just blame the federal ban. Now, a slightly different version of this argument is that, well, it's really about enforcement. The federal government isn't enforcing the ban within states, but the federal government would jump on anyone who tried to ship cannabis across state lines. And I think there's certainly that belief out there. I'll give you one example. Iowa was a rare state a few years ago. It's a CBD state rather than a medical cannabis state. But a few years ago, it legalized CBD for medical purposes. Its statute that legalized that authorized state regulators to bring in cannabis, CBD from other states like Minnesota. That was a way maybe to get this product to consumers much more quickly than you could if you had to establish your own cannabis industry. But the state attorney general advised them that the DOJ wouldn't like this and that the DOJ would crack down. I think that is baseless, though. I think that's an unfounded fear. I don't think the federal government is any more likely to enforce its ban against interstate sales than it is intrastate sales. Now we have the Cole memoranda from a few years ago, which provides one piece of evidence. That memoranda did say, hey, we'll take a hands-off approach to marijuana activities. We won't prosecute them unless you're violating state law or you're implicating some federal enforcement priorities. And the Cole memoranda did make one of those enforcement priorities, quote, preventing the diversion of marijuana from states where it is legal under state law in some form to other states. But I think all that language means in the Cole memoranda is that if you take marijuana from Colorado and you ship it into Idaho, which is a prohibition state, or some state that doesn't allow the drug at all, then the DOJ might step in. I don't think this says that, hey, if you take it from Colorado into California and California is okay with that and Colorado is okay with that, I think the DOJ would be okay with it as well. And that's certainly consistent with congressional spending riders, which are even more deferential towards the states, that basically allow the states to call the shots. Now, I don't want to say that federal law plays no role. There are some federal laws that would still complicate interstate sales. For example, interstate shippers like UPS and FedEx probably wouldn't handle shipments of the drug because they have to face the DOT and they have to have their driver's license by the DOT for these interstate shipments. But I want to suggest that federal law isn't the main reason why we don't have a national market today or these interstate sales. Instead, I think the bigger reason is that the states have blocked interstate sales. And they've done so in really two ways I want to focus on here. Most importantly and most obviously, the states have outlawed the importation of cannabis into their jurisdictions. Every state that has legalized the drug has demanded that all the drug that's going to be sold within the state has to be produced within the confines of the states. And these laws, although they don't get noticed all that often, they're blatantly protectionist. I think they're primarily animated by a desire to make sure that marijuana legalization and marijuana reforms generate local jobs. They preserve local cultivation and processing jobs against interstate competition. And states have adopted other protectionist pieces of legislation. For example, they require or say, we're not going to award licenses to non-residents. So they have a residency requirement even for owning these businesses, but those businesses certainly have to be located in the states. So I think these are animated primarily by a desire to protect local industries from out-of-state competition. The states have also impaired interstate commerce in a second way, and that's that they've adopted these idiosyncratic regulations of cannabis sales, including idiosyncratic and different regulations governing the testing, packaging, and labeling of cannabis products. I'm going to share one slide with you today that I think nicely sort of captures this, this issue. I think Christopher may still be sharing his screen. I could come back to this if in a moment. But the basic idea is that each state has its own sort of unique regulations of cannabis products. Each state requires, for example, a different warning symbol to be placed on those cannabis products. This doesn't completely destroy interstate commerce in cannabis, but it does make it more difficult for big national players to sell their wares throughout the land. Because if you're that edibles producer in Colorado, you can't simply take the same chocolate bar that's infused with THC and sell it in Michigan and Maine and Massachusetts and California. You've got to make a different chocolate bar for each of those because each one has to have a different stamp on it to warn consumers that the product has THC. So these are the reasons. These state legal barriers, I think, are the primary reasons we have these state markets today. So the second issue I want to get into is the question whether these state markets will survive. Can the state really do this? Can they block interstate markets in this way? And I think the short answer to that is no. That state legal barriers that have been constructed are probably unconstitutional under the Dormant Commerce Clause. That Dormant Commerce Clause, it's a doctrine that promotes free trade within and across the United States. The state bans on imports of cannabis are particularly vulnerable under the Dormant Commerce Clause. These laws are, again, blatantly discriminatory. They treat out-of-state producers differently than they treat in-state producers. And it's nearly impossible to defend those discriminatory laws under the Dormant Commerce Clause. To do so, the states would need to convince a court that they have a legitimate, non-protectionist reason for only allowing the sale of locally produced cannabis. And they'd also have to show that the absolute only way to achieve that interest, to serve that interest, is to discriminate against outsiders. And that's a tough bar to meet. In fact, with lots of other markets, the Supreme Court has invalidated bans on imports. For example, Dean's Milk, Madison, Wisconsin adopted a law that said the only milk you can sell in Madison is milk bottled in Madison. And the Supreme Court said that's blatantly protectionist, it's unconstitutional, we won't allow it. Now that would be the case if this were any other product. I think what's happened here is that because we have cannabis and because it's illegal at the federal level, the states have been able to hide behind that federal prohibition. I think the assumption has been, as long as that prohibition stays in place, Congress has effectively authorized the states to discriminate against outsiders. I think that's the tacit assumption here. For several years, really since the states started creating these cannabis industries, that assumption has gone largely untested. But a recent case in Maine suggests it may be wrong. In other words, this case, it's Wellness Connection, which was a case just decided on a preliminary injunction motion out of the District of Maine. That case held, it involved a challenge to a similar analogous state form of protectionism. This was Portland, Maine, saying you had to be a resident of Maine. In fact, you had to be a local resident in order to get a license to sell adult use cannabis in Portland. The court threw that out. The court said that is blatantly protectionist. We don't think the CSA amounts to congressional authorization for you to discriminate against outsiders. So if you're going to allow some people to sell cannabis, well, you've got to allow outsiders if you allow insiders to do it. Now, maybe the court got it wrong. Maybe an appeals court would see it differently and say, no, we don't think the Dormant Commerce Clause applies here. But I think the important thing is if this court is upheld, you won't need Congress to do anything. Even if Congress continues its stalemate on cannabis reform, I think these import bans are going to come tumbling down, especially as firms start to challenge them. Now, that other form of obstacle that the states have erected, the idiosyncratic state regulations, I think those might last a little bit longer. And the reason for that really is that right now we have 30 some odd different ways of regulating cannabis. There's no sort of consensus approach from the states. And the Dormant Commerce Clause, when it comes to these not protectionist, these sort of neutral regulations, and none of these are designed, I think, with a protectionist purpose on these labeling laws, for example, the states have designed. The Dormant Commerce Clause says these are only invalid when they impair interstate commerce. And the Dormant Commerce Clause here really punishes outliers. That's when one state does something differently than the other 49 states do. But we're not at that point yet. So for example, there are cases where the court will invalidate a state law that says, all right, your big semi-trucks have to use curved mud flaps. They'll say that's unconstitutional because the other 49 states require straight mud flaps. So anytime somebody has to drive through Illinois and put on new mud flaps, you're burdening interstate commerce. We're not at that stage yet, but I think we may be headed in that direction. I think already the states are trying to coordinate, maybe adopt common regulations of packaging and testing and labeling of cannabis products. Once that gets underway through efforts like the recently announced Cannabis Regulators Association, I think the Dormant Commerce Clause is going to speed it along. So if you get 20 or 25 states adopting a common packaging set of regulations, I think you could use the Dormant Commerce Clause to invalidate those holdout states that haven't towed the line and force them to follow the leaders. Now, the last question I want to get into just very briefly as my time's starting to run out is, if we have this emerging national market, should we mourn the loss of state markets? In other words, whose ox is being gored if the national market replaces these state markets? So here I want to say on the one hand, the development of a national market, I think, would be good for consumers. That's the classic economic story. Consumers will have more choice, they'll have more out-of-state competition, products will be cheaper, and so on. So classically, interstate competition is good for consumers. And I think that's a fair point to make here. But it's also worthwhile to recognize that moving from a state or 30 state markets to a national market is going to dramatically reshape the cannabis industry that we have today. And let me just give you a couple quick examples of that and then wrap up. One is that a lot of these small producers in legalization states are going to get squeezed out once they face national competition. I don't think they'll be able to compete with those large national firms, largely because of economies of scale. There was a discussion of that in one of the panels yesterday between John Calkins and Ryan Stoa, who's going to speak tomorrow. He's got a great book out on craft weed, which I recommend to you. But I think it's going to be hard for a lot of the firms that are doing business today within the states to actually compete with these larger interstate operations. The states have really artificially kept a lot of these smaller players in business by artificially capping the size of cannabis cultivators and producers. They can still do that, even if the Dormant Commerce Clause says they can't engage in protectionism. They can still say, if you're a cannabis producer in Massachusetts, you can't be bigger than 25,000 square feet. But the problem is they're going to face pressure from producers located in a lot of other states that don't impose those same square footage requirements, like California. California anticipated imposing size requirements, but abandoned those fairly quickly when it tried to implement Proposition 64. Now, I'm not saying that all of these small producers are going to disappear. That's not the message that I want to get across today. There's got to be a craft market, as Ryan Stoa, I think, would suggest. Some of those smaller firms would survive, but I think two items suggest that's not going to be such a big deal. One is that in other comparable markets like beer, craft producers are just a small share of the total market. In beer, it's about 22% in 2019. So there are some small producers out there, but they capture only a small slice of the pie. The other thing is craft doesn't mean local. So yeah, you might have, let's say, 1,000 craft producers of cannabis that survive this national market. But it's possible that every single one of them will be in either the Emerald Triangle in California, where they have a growing advantage, or in Oregon. You won't necessarily have craft producers in places like South Dakota and Alaska and so on. So apart from this sort of shifting production from some states to others and towards bigger suppliers, I think that consolidation in the cannabis market is also likely to affect the racial composition of the market. And I think that's an important point. The firms that are left standing in the national market, they're likely to be large, well-capitalized firms. Just to give you an example, Canopy Growth up in Canada has about an $11 billion market cap right now. And the problem here is that minority participation at that level of industry, when you're talking about a $10 billion corporation, minority participation at that level of industry is even smaller than it is when we're talking about smaller cap and medium cap firms. So you're likely to have an industry that is even more white-owned and operated. So this might jeopardize some state efforts to boost minority participation in the cannabis industry. Now, cannabis could address all these concerns. Cannabis or Congress could address all these concerns. Congress could adopt legislation, as I mentioned before, that authorizes the states to engage in discrimination. Congress could try to preserve these state markets, or Congress could say, we're going to have our own social equity program to ensure minority participation, or Congress could simply say, we're going to limit the size of all these cannabis companies. I think that the fact that we're going to have a divided federal government, at least over the next couple of years, likely with Mitch McConnell still in charge of the Senate, makes it unlikely that Congress will do anything, certainly anything to address social equity. So we may see the quick emergence of a national market without any federal regulation to prop up these efforts that the states have made. So we may end up in the end with something that's very similar to the beer market or the liquor market, where it's highly consolidated. So I'll end it there and turn it back over to Christopher and Rosario.
Well, thank you so much. That concludes the second of our three presentations. Our third one is from Professor Rosario Quirolo, who'll be bringing a comparative lens to the question. Her title is Advantages and Disadvantages of the Cannabis Regulation in Uruguay. And keep sharing your questions on the Q&A. Some of the speakers might even choose to respond in text, and then we'll field the rest in question and answer verbally at the end. We'll have at least 25 or so minutes. So Professor Quirolo.
Good morning to everyone. Thanks for having me. And thanks to Shay Webster for the invitation of participate in this symposium. So I'm very glad to be able to present the Uruguayan case. Thanks, Christopher, for moderating this panel too. So let me, I'm going to share a presentation. So let me start saying that actually I'm a political scientist, and I came up to study drug policy because I was concerned about how policies started in very unexpected ways, and Uruguay was one case of that. And now I'm very deeply interested on the policy impact of the legalizations that are occurring around the world. And the main message that I want to state in this presentation is that the effects of the way in which we legalize cannabis, and actually mainly recreational cannabis, might depend upon the policy model. So in a way, what I want to really bring to you and I want to take this opportunity to really reflect on that is how we are legalizing recreational cannabis, and how the way in which we legalize might have different impacts on the outcomes that we want to achieve with the legalizations. And well, first, I want to explain why Uruguay legalized cannabis, how. Then I want to say something about the lessons that we have been learning from the Uruguayan experience, that in a way is pretty short, but not shorter than any other of the cases, for example, in the United States or even in Canada, and some ideas for the future too. So why I'm so concerned about the policy regulations and how and given and put attention on the way we design the legalizations or the regulations. Well, let me explain why Uruguay in particular legalized cannabis and regulate the cannabis market. Well, it was the first country to fully regulate the market from production, commercialization, and consumption in 2013. And the reasons are very, very different from the ones that that brought legalization in the US and even in Canada. Mainly regulation in Uruguay mainly respond to a public insecurity demand. So the idea was that by legalizing cannabis, we will be reducing the leverage of criminal organizations tied to drug trafficking. And by doing that, we will increase public insecurity. A second purpose of reason for regulating the cannabis market was to decriminalize users. And a third one was increase public health. So there were, and this is also different from the US, there were no economic or fiscal purpose on the regulation. Actually, nobody talks about taxes, nobody talks about industry, nobody talks about nothing related with that. How we regulated the cannabis market? Well, it was not only different the reasons and the causes for the regulation, it was also different the mechanisms we came up to regulate. And in that sense, this was a top-down public policy. At that moment, President Jose Mujica, which was a president from a left-wing political party, the Frente Amplio, came up with that idea. And as I said before, it was on his agenda as a way to diminish the crimes related with drug trafficking and drug groups. So at that time, more than 60%, around 66% actually of Uruguayans were against the law. So it was an unpopular law. And despite that, because Presidente Mujica had the majority at Congress, the law passed and was approved. How we regulate? This is a highly government-oriented regulation. And the regulations that are defined in the law are strict. For example, there is a mandatory register for users. If you want to be a legal user, you have to be registered. There is a maximum amount of cannabis allowed for users. So if you want to be legal, you have to accomplish this maximum amount of cannabis, which is 40 grams per month, which summing up all the months is like 480 grams per year. No other advertisement or publicity is allowed. There is not allowed to sell to tourists, and no edibles, no tinctures, no oils are allowed, only flowers. So this leads us to these strict regulations, leave us with a model, which is what Hawkins et al. In 2015 defined as a middle ground model of regulating or legalizing cannabis. So the boxes in gray shows different alternatives of middle ground models, and actually the Uruguayan one presents some of those options. For example, home growing, for example, social cannabis clubs, for example, the government sells the cannabis through private pharmacies, but the government is the one that licenses firms to produce for the government, and the government is the one who distributes the cannabis through the pharmacies and fix the price that the cannabis will be sold at the pharmacies. So we have a middle ground policy reform, regulation, and which allow 3 ways, and I'm going to briefly explain the 3 ways in which we can access cannabis for adult users. Only adult users, which in Uruguay is those that have 18 or more, and these 3 ways are exclusionary. So as I told you before, you have to be registered to be a legal user, and you need to be registered just to one of these ways of access. So you have to be registered either as home grower or a social cannabis club member, or as a buyer at a pharmacy. You cannot do the 3 or 2 of them. You have to pick up one. At home grower, you are allowed to plant 6 female flowerings plant per household. At this moment, there are around 9,000 Uruguayans registered to be home growers, but estimates are that there are more than double that are registered. So in total, there might be around 27,000 Uruguayans growing. And there are no potency controls to the cannabis that is grown at households. The second option is to be a member of a cannabis social club, which are non-profit civil society organizations. We have at this moment more than 150 cannabis social clubs, which are allowed to plant up to 99 plants in the club, and they have a maximum amount of members of 45. So at this moment, we have around 5,000 Uruguayans that are members of cannabis social clubs. And something that is very interesting, that the surplus, because as I explained you before, there is a total maximum amount of cannabis that each registered user can have. So the surplus that cannabis social clubs and also home growers have, they must kind of be shielded to the government, to the authorities. So you can imagine that this is very, very difficult to enforce. And actually, well, it's very, and I mean, as I said, it's very difficult to really enforce that. So the surplus are not yielded to the authorities that are in charge of the implementation of the law. The third way is pharmacies. Actually, pharmacies are the most popular way of access at this moment. As I told you, the cannabis that is produced by 5 licensed producers, big producers, who who gave, so they produce for the government. So everything that they produce is sold to the government, and the government distribute the cannabis through the pharmacies. But there are very few pharmacies in the country that actually sell cannabis. There are only 14. Despite that, 42,600 users, Uruguayan users, are registered to buy at the pharmacies, and they can buy each time that they go to the pharmacy. They can get up to 10 grams. So per week they can go just once, and they have to register. So they indicate they sign with there is a digital way to control that. Well, as you say, this is a highly restricted regulation. And what we have learned about this model, this middle ground model of legalizing cannabis? Well, let me focus on the lessons that we have learned. As I said before, it has been very few years. Now the law passed in 2013, but the implementation really started in 2014. So we are kind of 6 years from the starting of the implementation of the law. But we have to focus on the purpose of that the law had in order to understand what we have learned and the lessons we can at this moment have from this way of regulating. So I will talk about public security, decriminalization, and public health. Public security, we can divide it into two brands. One, the law, the regulation had the purpose to reduce the black market and to kind of reducing also narco trafficking. And on the other side, to reduce the contact of users with illegal activity. Talking about the black market and focusing on narco trafficking, if you know about if you know about marijuana, you know that it was very kind of ambitious to think that taking out cannabis from narco trafficking will be a really something important to reduce narco trafficking, because cannabis is not like the main substance that narco traffickers really make business of. So that part of the regulation were kind of really too ambitious. So but in order to reduce the black market, what the government did was to fix a low price at pharmacies. And now you can get per 5 grams, for you have to pay $7 per 5 grams of cannabis. So this price is really very competitive with illegal cannabis. And in that sense, many traditional dealers, I would say that most of traditional dealers really stopped selling cannabis because it was not more a business. But because this is a very highly, because the regulation is really strict, it's a highly regulated model. So there were some problems at the supply side, and one was the shortage of cannabis at pharmacies. This is just a picture of a pharmacy in which people are making a line, because if they don't go early in the morning, the pharmacy there was shortage and they run out of cannabis, so people don't have access. So actually, some people, media went to the lines and asked people that were waiting there, and they say, you know, I came here to be legal, but now they run out of cannabis, so I will go with my dealer. So these kind of things happen, especially at the beginning of the implementation, not right now. So this really create a new kind of gray market. In a way, this gray market was created by a shortage of the legal marijuana at pharmacies, also because there was not enough pharmacy in all the territory, and due to the strict regulations that prohibits to home growers and social cannabis class to serve that surplus, and also the prohibition to sell to tourists. So this all those factors together really develop a gray market in in which the actors that operate in these gray markets are different from the ones that were in the black market before. Now there were what we name it here as bolloneros, so they sell flowers in parks, and these are people that were not previously dealers. They are just maybe some are growers that sell their surplus, but they don't sell other drugs, for example. And also some fake cannabis social clubs that only sell cannabis. So in a way, the reform helped achieve the objective of reducing the cannabis black market, but not on narco-trafficking, because as I said before, this was too ambitious. The other brand of this was to diminish the contact of users with illegal activity. And in that sense, actually, we have like 1/3 of annual users are legal. And even among those that are not registered, there is less contact with dealers and illegal drugs selling points than there were before. Before regulation, 70% of the users were in contact with dealers or illegal drugs that sell, or illegal drugs selling points that also have other products, other substances in their offer. And in 2017, this was decreased to 50%. Also, on the contrary, there was an increase in those that buy from friends, that increased from 30 to 50%. So in that sense, the reform and the regulation help achieve the objective of market separation. Second, the second purpose of the legalization was decriminalization. Despite cannabis use and possession for personal consumption in Uruguay was legal since 1974, police officers and judges interpret this kind of personal consumption in a very different ways, and that leads to arrest and imprisonment of cannabis users. After the regulation was passed, actually there were no people in prison for using cannabis, and as I said before, diminished the contact between users and illegal sellers. And there were very, very few incidents among growers or cannabis social clubs and for example, the police. So in that sense, we can say that the reform helped achieve the decriminalization purpose. Finally, public health. I will talk about two things here: substance quality and how to protect young people from early use. Let me start with substance quality. Well, recreational cannabis that is sold in pharmacies, which is the cannabis that is highly controlled by the government or the government licensed firms to produce it, is very low in THC in comparative terms. So the cannabis that is sold at the pharmacy, they have not more than 9% of THC. Okay. Home growers and cannabis social clubs produce a different product with higher potency level. Actually, we know from a cannabis social clubs member survey that on average, the substance that they use is around 22% of THC. So is it working, this idea that the regulation will control the quality of the substance? Well, before the regulation, 2/3 of frequent marijuana users used to buy something that is named prensado, which is a cannabis that came from Paraguay and is from a very, very, very bad quality. And in 2017, only 14% of the user was using prensado. And on the contrary, the use of flower had increased from 1/3 to 86%. So in that sense, I think that the objective of substance quality was achieved. What about protecting young people from early use? Is that these middle ground options that Uruguay took this approach work for that? Well, of course, there is a prohibition to sell to minors. There are no edibles or other derivatives allowed, no advertising. All these regulations in a way were thought to protect young people. But actually the media campaign and education campaigns and the guidelines for risk cannabis use came up kind of late, in only 2018. And And the question is this working? Is this really the regulation protecting young people from early use? Well, as it's happened in other countries, in other parts of the world, life prevalence has increased through time among young people, and this was even before the regulation. As you see, numbers were escalating. But there is a recent paper by Laqueur and other colleagues, Magdalena Cerda, Ariane, and other people, in which they look at the use of cannabis among adolescents, and doing a synthetic control analysis, they find that there is no short impact either on pulse mouth prevalence or frequency of use. If you see in this chart, the two lines, the one that is black is the case of Uruguay, and the synthetic control that is made with Chile that doesn't have a regulation, so cannabis is not legal. No recreational cannabis is not legal. Is that there is no statistical difference between the two, and neither there is a statistical difference in the frequency of use. So it seems that at least in this short-term impact evaluation, there is no negative impact of the legalization of the regulation on the use of cannabis among adolescents. Of course, that I have to wait more time to see the longer impact, and of course, there is still some other things to use, but to analyze. But at this moment, we can say that this middle ground reform helped achieve the objective of quality. No, there is no impact on protecting young people, because you see, as I show you, it's not that this line went below the gray one, but actually it didn't make things worse. So one thing that we can say is that it is very demanding also for a regulation or a legalization that in a way makes things more available, even for minors that are not allowed to have the substance legally. But the substance, it is more available right now. So it is really very ambitious to think that the things are going to be better. What I think that is more realistic to think that we expect that the things don't get worse. And at least from this evidence, we see that things are not getting worse. So there is no impact. But more work is needed on test the impact on adults, on heavy users and potency, something that also John Hopkins made this point yesterday at the first panel of this symposium. And I think it's very, very important to see in the long term, and also to pay attention on the impact on heavy users and potencies. That's something that is not, that has not been done yet for Uruguay. So to sum up, after 6 years, lessons from the Uruguayan model of cannabis regulation. The way in which Uruguay regulate, and with these strict regulations, I think that it helped to decriminalize users, to diminish the contact between cannabis users and illegal sellers, to improve substance quality and controls, to reduce the black market, but also create this gray market that in a way we name it gray because it brings cannabis that is kind of produced legally, but is sold illegally because it's not allowed to sold, neither to tourists, neither to people that is not registered, but creates this gray market due to the shortage in pharmacies, due to the emphasis on registration and quantities, and to this also restriction of not selling legally to tourists. So in a way, this restricted model also generates this gray market. So to finish, I want to say that the thing that I declared at the beginning, I really believe that the effects of recreational cannabis legalization depend upon the policy model. And I really think that there are options outside the commercial model, which is the most common use at the moment, and the one that has been followed mostly by the states in the United States. But we have to pay attention to other options, and also thinking on this thing of legalizing cannabis nationally. We have to pay attention to middle ground options, and even more countries start to think about this. You know, New Zealand almost passed a law just at the end of October. So many other countries are thinking on that. So we have to pay attention not only to the commercial model, also to these other middle ground options, because the different models of cannabis legalization might produce different results. And we have to really study that. We have to take advantage of the exciting variants of policy design that we have, and came up with evidence to see which are the effects of these different policy designs, study the impact of the legalizations in a comparative way. This is the way that we will learn more and make policies that are more based on evidence. Thanks a lot, and I will be glad to answer questions.
Well, wonderful. Thank you so much. It's great to have all three of these perspectives, and I'll ask all the panelists to join us on screen again. What a wonderful multi-level. We had state considerations, federal considerations, comparative international considerations. So one question I might suggest we start with is Michelle Caskey's from the chat, which she asked a pair of them almost an hour ago. But I think they're overarching. You know, what is the role of racism and hostility to political reform in the adoption of the CSA, the role of centralized administration, and some history going back to the Nixon tapes as evidence of the political objectives of the CSA?
I'll kind of start in talking about it. And so I think that there's no doubt that there's a disturbing history of racism in drug prohibition generally, and in the Nixon era in particular. But with that said, I don't think that the CSA was born out of that as much as born out of sort of the considerations about regulatory reform. I think Nixon really carried out sort of his war on drugs agenda more through things like the creation of the Drug Enforcement Administration, which happened after passage of the CSA, and other kind of related enforcement choices, and sort of, you know, including efforts to get more funding both for the DEA once it was created, and prior to the DEA's creation for the Bureau of Narcotics and Dangerous Drugs, the predecessor agency of the DEA. The CSA itself, you know, kind of mainly placed drugs that were already illegal under one regulatory framework. And so in terms of just kind of the Nixon drug war, that could have been achieved, I think, just as much under the pre-CSA drug prohibition regime. Because before the CSA, all, you know, of the drugs that are, you know, what you would think of as the illegal drugs, marijuana included, were illegal under federal law. So I kind of tend to think that while there's no doubt that the Nixon, there's a very disturbing history of sort of racism in Nixon's view of drug enforcement and approach to drug enforcement, I think it's a little bit outside of the CSA. And I'd recommend an article, I think from maybe 2004. So the article by David Courtwright about, who's a historian, that's called something like how big tent reform became a punitive law about the Controlled Substances Act, because I think the CSA itself really was sort of viewed more as a big tent reform. And in fact, the CSA, is part of the overarching legislation which CSA was enacted, it did away with then existing federal mandatory minimum sentencing laws. Before the CSA, there were mandatory minimums that were repealed as part of the CSA, and then those mandatory minimum sentencing laws, which have been a big part of the drug war, were revived in the 80s. But the CSA itself, if anything, actually was maybe a little bit reform-oriented on things like punishment, because it did away with the mandatory minimums. And that was not something that Nixon was backing, but that did come from Congress as part of
Anything to add, Robert or Rosario? So let's pick up Michelle's next question, and let me invite others to submit your questions on the Q&A. Can nations unilaterally withdraw from international prohibition treaties? Anyone speak to that, Rosario?
I can start. I can tell the experience of Uruguay. Actually, at the beginning, this was an issue, and actually there were some conflicts, and it was like the threat that this will have an impact on Uruguayan economy and many other things, and also internationally. But after some time, and I would say after the first year, despite those threats, nothing happened. So everything went okay. And I think that the main issue was after some time when the pharmacies started to sell cannabis and using the banking system. It was a conflict with the banking system, with the international banking system, actually with Bank of America, with kind of threats to the Uruguayan bank system to not making more business if they use the banking system to sell cannabis. And the pharmacies went out of using credit cards, and they just went to do business with cash. But that was, I think, that the main international interference that we had. But nothing happened, and I think that the experience of Canada was also similar.
I just add, one of the quirks about international treaties is that they require member states to treat certain drugs, especially marijuana, as tightly regulated substances. They don't envision sort of the legalization for all adult use. That's certainly off the table under international conventions. But they wouldn't even allow, for example, the United States to move marijuana below Schedule 2. So that's a bit of a non-starter. So countries can withdraw from these treaties unilaterally if they want. Just a question whether they'd want to gut them in that fashion. That'd be a pretty dramatic move, especially for a country like the United States to take, because there are aspects of these treaties that we might benefit from, even if we might chafe at the controls they require for marijuana. They might help the United States prevent some imports of fentanyl and other opioids. So it's a dramatic step. You can take it, but the ramifications would be pretty severe, I think.
I'd just kind of add quickly, kind of following up on that, is that it could also, in theory, be possible to withdraw and reaccede with a reservation, and that's something Bolivia did with respect to indigenous uses of the coca plant in 2012, 2013. So I guess, in theory, that could be an option as well. But I think it's one thing to withdraw and reaccede with a reservation on a very limited thing like indigenous uses of the coca plant. It'd be, I think, another thing entirely to withdraw and try and reaccede with a reservation about whether marijuana can be legalized entirely. So, it would be, I think, a very dramatic thing. I mean, it can be done, but it would be certainly a very big step to do that, even if under kind of a withdraw and reaccede type of a scenario.
Appreciate that complexity. As it happens, Alex, we have a question for you up next from Jay Wexler. He's asking, you mentioned that the DEA's interpretation of the term abuse in the CSA has largely been something like lots of use, which is highly unsatisfactory as a definition. Are there other better definitions of the term abuse in other statutes or regulatory contexts or outside the legal context that Congress could potentially adopt or build on if it were to amend the act? So what do we do with this concept of abuse?
Yeah, I mean, I think that it's a difficult question. I mean, there's certainly other potential definitions, a lot of debate. And I should note, it's not the only thing that the DEA points to, because the DEA will also look at, other potential impacts, the potential for people to develop substance use disorder and that sort of thing for substances that are not as widely used, because there's certainly plenty of non-widely used substances that the DEA finds has a high potential for abuse. So there are other factors that the DEA will look at. as well. And so I do think, to a degree, some of the factors that the DEA looks at for substances that are not as widely used are the kinds of things that I think many people, it probably would be more agreement about as being relevant to abuse potential, right? Things like the degree to which people might develop substance use disorder with the substance, the severity of substance use disorder caused by the substance, the potential for fatal overdoses with use of the substance, or those kinds of things. And so I think those are the kinds of things where there's probably a little bit more agreement on. Now, obviously, of course, that kind of presupposes the use of kind of that abuse potential criterion as a criterion for scheduling to begin with. And there are certainly some people who, might object to that idea. But as long as that is part of, I think, the criterion for scheduling, there are those other kinds of considerations, things that the DEA is already factoring in for less widely used substances. But the widespread use of the substance really is, I think, the factor that is the most controversial in terms of how the DEA currently envisions a potential for abuse. A lot of the other stuff that they look at are probably things that there would be more widespread agreement on in terms of aligning with abuse potential.
We have another question from Jay Roy, or really I think it's a comment, and I think it's responding to your talk, Alex, but I think it might be good to get Rosario and Robert to maybe triangulate on it. So let me read the comment and see if they have any reactions first to build on or bring light to. So Jay Roy is noting that few people discuss the CSA contestations to rescheduling cannabis. I never knew their arguments for abuse was defined by how many people use cannabis outside of medical treatment, and never knew the issue that cannabis can't be manufactured as a consistent dose was a large reason for the Schedule I label as well. So a lot of people don't know this. They know the basics of Schedule I, but not the more in-depth arguments. Robert or Rosario, did you have any reactions or insights on that particular emphasis?
Yeah, I can address that. I think those are two astute observations. I want to talk about the second one a little bit, the inability to sort of titrate the doses and keep it consistent in experiments. So to demonstrate that cannabis or any other drug has valid medical use, typically what the DEA requires is kind of the gold standard. Double-blind, large clinical studies. And in those, it wants the scientists conducting the studies to administer sort of a consistent dosage of the drug. And that's tough to do with something like cannabis, a plant-based substance, especially if you're not extracting THC. If you're giving someone something to smoke, it's very tough to figure out how much of a dose is each person getting. So it sort of undermines all those controls in the study. And I think that the broader issue there, it may point to Alex's sort of thinking about broader CSA reforms. I think the CSA was really designed as a statute to govern lab-made drugs, things that you create in a laboratory rather than things you grow in a field. And maybe one of the reforms that could be considered is do you take cannabis and maybe psychedelic mushrooms, peyote. I don't know if they confront the same, sort of inconsistency problems, but maybe you need to take naturally based substances off that scheduling system and create some other regime for them. But just a thought about broader reforms to the CSA and some lessons we can glean from cannabis.
Great. And Rosario, how did Uruguay broach these two issues about frequency of use and consistent dose?
This was also part of the discussion at the beginning of the implementation of the law, but actually in a way the Uruguay legalization is kind of weird, because we started with regulating recreational cannabis and later medicinal cannabis, which is something that is not like the general patterns that have followed other countries, that they started with the medicinal cannabis and then go to the recreational cannabis. So because as I tried to explain in the presentation, the purpose was this was more related with, you know, narco trafficking, public insecurity, and all. So the main issue was like what is happening here with the recreational substance and not with medicinal. And this is more, I think those questions, I think that are more related with the medicinal issue. And actually, the law of recreational cannabis passed in 2013, and medicinal cannabis really started to being implemented last year. So in 2019, almost 6 years after, because all these discussions that we are having now concerning the US also occurred when Uruguayan political system started to think how we have to deal with medicinal cannabis.
Well, thank you. We also have Julie Steiner just submitted a question about the potential for a broader international market, perhaps including Canada, you know, crossing national borders as well. Would you like to pick that up?
Yeah, maybe I can take a first stab at that. Yeah, that's really thinking ahead. There has actually been some international trade in some cannabis products, especially CBD, a lot of it originating out of Canada and being sent to Europe. Israel is also involved in some of this. So there is sort of a nascent international trade in some cannabis-based products. I think that could happen. It'll require some trade negotiations, especially given all those single conventions that we talked about a few moments ago. It would require some arrangements between the US and Canada or Uruguay or other, you know, Mexico as well is sort of moving in this direction. But yeah, I could, you know, that would probably require federal legalization, Congress to do something, either deschedule cannabis or adopt something bolder like the Moore Act. Before that happens. But I think that's definitely on the horizon, just a little bit farther out once we get to that national market, maybe a few years beyond that, to involve the United States anyway.
Well, if any of the other panelists, we have about 3 minutes, would like to either touch on that or pull a thread from something you heard from one of your fellow panelists, or just leave us a parting word, please do.
I thought one interesting thing that Rosario pointed out for Uruguay is just that cannabis is being sold in the equivalent of pharmacies. And in the US, we have this segmented market where, you know, medical cannabis is sold in medical dispensaries, adult use cannabis is sold somewhere else. We also see chains like CVS saying, we're no longer going to carry cigarettes because those are bad for your health. So I'm wondering how that, you know, is there any of that tension in Uruguay? I'm just sort of curious how that works for a pharmacy to be selling both a social substance or adult use substance, but also a medical substance.
Yes, thanks for the question, which is really a very good one, because at the beginning that was an issue. Now the government decided that the delivery system will be, the dispensary system will be through pharmacies, and pharmacies didn't want to sell. Actually, we run a research with owners of the pharmacies, and they say, you know, we have this old lady, they used to come here and it's trust on us. And now how are we going to say to her that we are selling drugs? And actually, as a researcher thought, but you always sell drugs, legal drugs, but you sell drugs all the time. So that was the question, but it was, of course, it was an stigmatized drug. So actually many owners of pharmacies didn't want to sell it, and they didn't adhere to the system. That's why there are very few pharmacies that are selling cannabis. And because also they cannot sell using the financial system and using banks, the big ones, the brands, the chains of pharmacies that they know they have many locals around the country, they don't get into the system because they will lose money. So this is only some profitable business for small pharmacies that sell in neighborhoods that they are very oriented to their population, and this has been a problem. using pharmacies because they was not connected to sell cannabis, and in particular because we at the beginning they were just selling recreational cannabis, not medicinal.
Well, thank you so much. That takes us to the top of the hour and concludes our panel. This is a fantastic conversation with all three of you, and thank you for I saw over 50 guests at one point in the audience. So our next panel is at 12:15, Historical Perspectives on Marijuana Prohibition. If you've registered, you should have already received a separate link or will shortly for that panel. So we will reconvene at 12:15. I'm sorry I can't direct you to the beautiful lunch buffet in the lobby, but I'm sure you'll have a nice PB&J in your basement or whatever the equivalent is. That's what I'll be doing. Thanks, everyone, and stay safe.
Bye, take care.